Some abortion rights proponents argue that abortion restrictions violate the Equal Protection Clause of the 14th Amendment because they constitute sex-based discrimination. We recently published this blog post by practicing attorney and pro-life atheist Patrick Copeland, explaining why the equal protections argument isn't a sufficient challenge to abortion restrictions. First, Copeland explains that there are different kinds of rights and different classes that receive different levels of protection from the Equal Protections Clause. Classes such as race, ethnicity, religion, and national origin receive the highest protections, and any laws that might infringe on those classes must pass strict scrutiny. This basically means that most laws that seem like they might infringe on those classes get struck down by courts. And there are other classes such as gender which receive the second highest protections, and laws that may infringe on those classes have to pass intermediate scrutiny tests. But outside of those classes, the Equal Protection Clause isn't generally triggered with any other law as long as the law is rationally related to a legitimate government interest. The law just has to pass the rational basis test. It's really hard for laws to pass the strict scrutiny test, and it's not that hard for them to pass the rational basis test. So previously, Roe v. Wade found that the right to abortion, at least before viability, is a fundamental right found within the Constitution. 20 years later, Casey v. Planned Parenthood found the same thing, although Roe and Casey didn't totally agree on where exactly that right is in the Constitution, but they both agreed that it is in the Constitution and it's a fundamental right, which means that laws that restrict it have to pass strict scrutiny. As Copeland put it, the right to abortion received the height of constitutional protection under Roe and Casey. But then Dobbs overturned Roe and Casey. This means laws restricting abortion are no longer subject to the strict scrutiny test or even the intermediate scrutiny test. They're subject to the rational basis test. If it were true that abortion restrictions meant unconstitutional sex-based discrimination, it would be harder to pass those restrictions because they would have to pass the intermediate scrutiny test instead of the rational basis test. However, the Supreme Court has repeatedly said that abortion regulations do not discriminate on the basis of sex. It's worth noting that in Roe v. Wade and Casey v. Planned Parenthood, they didn't even bring up this argument. And in Dobbs, they flatly rejected the theory, stating it is squarely foreclosed by our precedents, which establish that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such regulations. In one of those precedents, the Supreme Court explained there are common and respectable reasons for opposing abortion other than hatred of or condescension toward women as a class, as is evident from the fact that men and women are on both sides of the issue. Thank you for acknowledging pro-life women. In summary, Copeland explains that while the equal protection argument for abortion seems clever at first glance, a deeper dive shows that the argument was never really viable. If it were, it almost certainly would have shown up in either Casey or Roe, where the Supreme Court heavily considered and explored the various nooks and crannies within the Constitution where a right to abortion may exist. In reality, the only Supreme Court case law directly addressing the argument holds that abortion restrictions do not violate the Equal Protection Clause.